Mr. Perl.
Chairman Pierce and members of the board, I appreciate the opportunity to be here to address the board on behalf of the Tennessee Chamber of Commerce and Industry, which represents both large employers and small business owners throughout the state of Tennessee. In the news release on this notice of proposed rulemaking, the MPRM, Chairman Pierce, you're quoted as stating that such proposals are intended to improve the process for all parties in all cases. Regretfully, in our view, the board's approach does not meet this high standard. The MPRM proposes a bright-line numerical rule requiring that questions concerning the eligibility of potential voters comprising no more than 20% of the overall unit be resolved post-election if necessary. We regard this approach as ill-advised and destructive to the interests of employers and will lead to even greater delays. Under the MPRM, the disputed supervisory status of certain employees would not be resolved pre-election. And this uncertainty leaves employers more vulnerable to unfair labor practice findings based on the conduct of employees whose supervisory status prior to the election was in dispute. In our view, the supervisory status must continue to be litigated, 20% or even 10%, and not relegated to the challenge ballot procedure and post-election hearing. A case in point is worth looking at. It's a case I personally handled many years ago. It's ITT lighting fixtures, beginning 249 NLRB 441, 1979. ITT is a poster child for how protracted litigation results when critical unit issues are not resolved by the board pre-election. In ITT, following the filing of a union petition for an election, the company sought at a pre-election hearing the exclusion from the bargaining unit of its 33 group leaders on the basis that they were supervisors. At the hearing officer received considerable evidence on this issue, which under the MPRM he would not because the group leaders constituted approximately 10% of the unit. However, the regional director chose not to make a determination, but instead ordered that they vote by challenge ballot. And this left the employer in a difficult dilemma. The company's hands were tied because, as explained in the dissenting opinion in Bear National, which is prominently mentioned in your MPRM, if the employer is wrong in its belief that the group leaders constituted statutory supervisors and restricted them from engaging in union activity, it would trounce on the Section 7 rights of employees, and that such conduct would be found to be unlawful and objectionable. I hope I didn't cause that here. But following
you have our attention.
Yeah, following the election won by the union, there existed some 5 years of subsequent litigation, all the way to the United States Supreme Court. In the end, the election which the union won 5 years earlier was vacated and voided. The anatomy of ITT lighting fixtures represents a clear and present danger of what can happen if the board does not provide for the pre-election litigation and the resolution of vital supervisory issues. As correctly observed in our judgment by members Miscamara and Johnson, by deferring an appropriate hearing about the important issues like supervisory status, elections will be accelerated, but in the end, it will significantly lengthen the time that it takes to completely resolve election issues, causing added expense to the parties and to the government. The reality is that administrative shortcuts in resolving vital issues pre-election in the name of streamlining the election process causes unfairness and adverse consequences to many parties. Real-world experience, and those attorneys who are here today on both sides have it, demonstrates the fallacy of the board majority's premise that parties summarily use pre-election hearing process established under Section 9 of the Act merely to delay the conduct of an election through unnecessary litigation. The bright-line rule proposed by the board that eligibility and inclusion questions affecting no more than 20% of eligible voters be resolved post-election, in our view, is arbitrary, it's impractical, and it's antithetical to the self-professed high standards which this board and prior boards has set for itself in the conduct of representation elections.
Thank you.
I was also litigating cases in 1979, including one with ITT. But your example, I guess, to me, demonstrates that this, in fact, has been the board's practice for 35 years, at least. I mean, based on your example, at least 35 years, that there are issues that even when evidence is taken, that the regional director does not resolve. And even if the regional director does resolve them, there may be an appeal, a request for review to the board, so that they're not finally determined, typically until, I assume in your case, post-election, right?
Well, I have two responses to your question, Member Schiffer. The first is, there was a record developed pre-election in ITT lighting. So when this case went up on a technical 8A5 refusal to bargain, the court had a record before it, went to the Second Circuit twice.
Yeah. And it was resolved, the supervisor issue was resolved by the board?
The first decision of the Second Circuit remanded it to the board. Mm-hmm. The board, based on the record that had been established by the hearing officer, made a determination on the alleged supervisory status of the group leaders. The case went back to the Second Circuit, and this time it denied enforcement of the board order. It vacated the election. The petitioner in that case filed a petition for cert to the United States Supreme Court, and it denied cert in a split decision. The second response to your question is yes. For 35 years, even more. The board has heard these kind of challenges. They have taken evidence. But as the chairman noted earlier, a regional director has the discretion, and I believe you brought this out, not to make a determination. So our position is not only should this issue be litigated, whether it's 5%, 10%, or 20%, the board should follow the dissenting opinion in Bear National Inc. and make determinations of these vital issues. Because if the goal is to improve the process for all parties in all cases and to expedite elections, accelerating the election on the front end, but delaying it considerably in a matter of years on the back end is not, in our view, the expeditious resolution of representation questions.
So you would propose not only does the board not adopt the proposed 20% rule, but that it in fact rescind the current practice?
I would characterize it as modifying the current practice, because in most cases, in my experience, and I've been practicing first with the board for 4 years in a regional office and then here in Washington, as well as in private practice for over 40 years. In over 90% of the cases, regional directors, if they hear the case through the hearing officer and take the evidence, they will make a determination. In the ITT election case, the regional director erred by not making a determination because the record was there and could have saved years of litigation had he done so.
Yeah, but my question is, you're suggesting that the board undo its current practice.
I am suggesting that the board follow the dissenting opinion in Bear National and first hear the case, take the issue, make a record, and make a determination. It will save considerable litigation on the back end.
But here's what I don't understand. I mean, do you acknowledge the concern as being realistic that if there's simply a handful of employees that might be at issue, that could be used as a stumbling block to either getting to a stipulated election agreement when there should be one, simply because the leverage in forcing an election and a delay may be too tempting?
Well, I think that there are a lot of competing interests in leading to agreement on a stipulated election. I was involved in a case several years ago where only one individual was in dispute. The unit consisted of approximately 40 employees. One individual, because that was a pivotal individual. This individual was a claimed supervisor, according to the company. He was asserted to be an employee by the union. The individual was responsible for collecting union authorization cards and for leading the union drive. So here's one individual out of 40, but it was pivotal. And that issue is there's a necessity to determine whether that individual is a statutory supervisor or a rank and file employee. And whether it's 1 or 100 in some cases, it depends on the facts of the case.
Well, aside from supervisory issues, I mean, would your view change if we're talking about unit placement of a relatively small number of individuals?
Yes, my view is different on unit placement of other individuals. I think the supervisory status is the one category that must be litigated in each and every case where they are in dispute, regardless of the percentage number. And I think issues of inclusion and exclusion in terms of the present system going back 35 years ago is less severe. However, under specialty health care, now there's a different standard. I assume that goes to scope of unit, and under the NPR would be heard in each and every case. But if it's not, then those issues are vital as well.
Mr. Perl, thanks for mentioning this case as an example. I mean, you refer to it as a poster child, and I just want to, in terms of those particular issues that you're bringing to our attention, one is that the case took, I'm looking at the second appearance before the Second Circuit, which was in 1983 from 1979. So the case took 4 years to litigate. Is that right?
That is correct.
And one of the issues in the case was whether people were wrongfully included or excluded from the unit, but another issue in the case was whether or not those people may have inadvertently affected one way or the other the sentiments of other employees who were voting. Is that right?
That was the basis, remember, Ms. Gamera, of the objections filed to the election by the company, and was the basis of the technical refusal to bargain.
So it's really a spillover. The percentage of people who are at issue is not necessarily indicative of the percentage of employees who are voting that could in some way inappropriately be influenced by what the disputed group ends up doing or saying.
Well, that is correct, and that's why the notion that this issue could be resolved through the challenge ballot procedure is just not realistic. I mean, there are other impacts of disputed supervisors on the conduct of the representation election. I truly believe this board wants to get it right, and I bring this case to the board's attention because I think it represents the challenge, not only to practitioners and parties, but to the board of how do you have an expedited procedure? And what does that really mean? Should it be expedited only on the front end, or is it expedited through the totality of a representation process? Certainly, I don't think any board member here today would agree that 5 years of litigation over this election was an expeditious way to resolve representation cases. And I think there is a challenge here. I applaud the board for searching to improve the process, and I certainly accept the chairman's goal here, that the process should be improved for all parties in all cases. And I think that's the standard. To me, the bright line standard is not 20%. The bright line standard is what the chairman said, improve the process for all parties in all cases. And the 20% rule and the approach recommended and taken in the NPR clearly, under any standard, does not improve the process for employers or the employees.
Thank you very much.